pose with the fans. Pose with the pose with the pose with the pose pose with the fans. Pose with the pose with the pose 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 with the fans. Pose with the fans. Pose with the fans.
Guys, imagine you guys go to sleep as a director and the next day, boom, you are retired. You don't even get a cake for a farewell party. Which this happened in a case Tung, which is involve a removal director, statutory breach of duties, and corporate governance. So here's the story. To start off, this case is about conflict between a shareholder and a director of Institute Pemandu Maju Jaya Serendian Berhad. And the plaintiff in this case are minority shareholder and former director who claimed they're wrongly removed from the company. And the defendant, who in control of the company at that time, had filled the form and that said that the director and the shareholder are retired. So, but here's the catch. There's no AGM and no audited account were prepared for almost 8 years. Who brave enough to spill the cooperative for us? Like, what actually happened in the company and how's the conflict started?
All right, let's break down the fact of this case. The dispute revolves around Institute Pemandu Maju Jaya Serendian Berhad, a driving school company. The plaintiff, Tung, and two others were minority shareholder and former director. The defendant, Hing, and two others were the controlling director. The conflict started when the defendant filed Form 49 with the Company Commission in 2016, falsely stating the plaintiff had retired as directors. But here's the twist. No annual general meeting, which is AGM, were held from 2010 and 2017, and no audit account were prepared during this period, violating the Companies Act 2016 and the company's Article of Association. The legal relationship here is between the director and the company shareholder or the company shareholder. The plaintiff argued the defendant breached statutory duties by acting ultra vires, which is beyond their power to remove them unlawfully. The High Court of Cebu heard this case. The key issue were one, whether the Form 49 were valid, or whether the defendant failure to hold AGMs and prepare account breached the law. Okay, so now we know there was a drama, but what were the plaintiffs really after? What did they want the court to do? Revenge, justice, or just proper paperwork? And which part of the Companies Act did they wave around like their legal lightsaber?
In the case before the High Court of Cebu, Judge Lim Hock Leng presided over dispute involving alleged breaches of Companies Act. Here's what happened. In validity form of Forms 49, the plaintiffs challenged whether the company's annual return Forms 49 were properly filed or compiled with legal requirements. After they challenged, they failed to hold AGMs and prepare accounts. This will cause the defendants failed to conduct annual grand meetings and did not prepare the financial statements, which violates the Company Act. In the court, the plaintiffs were asking for declaration on Forms 49. The company is either to invalidate 5 forms or compel proper filings. If the court declares them void, requiring the company to refile the correct returns. If not, the company will be penalized. Plus, the court orders were for compliance to compel AGMs to be held within under Section 340, Subsection 1, Companies Act 2016. Private companies must hold AGMs within 6 months. If not, the plaintiffs can demand the court to penalize the company. The company must prepare audited accounts based on Section 248 Companies Act 2016. If accounts were missing or falsified, the court could order an audit or an appointed accountant to investigate. Alright, now that we know what the plaintiffs were demanding and how the law applies, let's cut to the chase. What did the court decide in the end? How did the Companies Act actually come into play in the ruling? And here's the real question. Do you guys agree with the court's decision, or do you think they got it wrong? Don't hold it back. We want all opinions.
Well, Azmi, to answer your question in this case, the High Court ruled in favor of the plaintiff, declaring that the defendant had breached their statutory duties under the Companies Act 2016, particularly by failing to prepare audited financial statement and to hold AGMs, which is the annual general meeting from 2010 to 2017, as required by Section 248 and Section 340 of the Companies Act 2016 and in the violation of Article 92 of the Companies Article Association. The defendant has submitted Form 49 stating that the plaintiff had retired as director, but the court held that this form were null and void because the director removal must be done via ordinary resolution passed by members in the general meeting, not by board resolution as outlined in Section 206(1), Section 291 and Article 84 of the company's constitution. The court found that the defendant acted ultra-vires beyond their powers and issued orders restraining them from acting as directors, directing them to return all the company's documents, and requiring corporation to audit the accounts from 2010 to 2017. I agree with the court's decision as it upholds fundamental principles of corporate governance, shareholder rights, and fiduciary duties, emphasizing that directorship is a position of trust that must comply with the law and the company's constitution, not personal interests or internal power struggles. But wait a minute. In the epic clash between the directors and the shareholders, who emerged the victorious? And what was the courtroom moment that sealed the deal?
Okay, Sashini. In this case, the plaintiff Tung Kwok and others win. The court ruled in their favor because the defendant had clearly breached duties under the Companies Act 2016 and violated the company's constitution. These are serious violations that affect transparency, accountability, and the right of shareholders. As a result, the court declared the Form 49 null and void. The defendant were prohibited from acting as director, ordered to return all company documents, and required to cooperate in auditing the company account from the missing years. The decision emphasized the importance of corporate governance, shareholder right, and legal compliance. It showed that directors cannot act beyond their power for personal gain and must always follow legal procedure. So, after all this drama, what's the real fallout? How will this affect the company, its shareholder, the director, and even the stock price down the line?
Alright, picture this Kuzai. If the company just ignore all this problem, it's like trying to drive a car with a flat tire and no steering wheel. It's not going to end well. So let's break down what's really at stake. For the company, not holding AGM since 2009 and not preparing official financial report breaks the rules set by the law and the company owns rule. This can lead to fine from regulator, cause problem in running the business, and make people lose trust in the management. For the stakeholder, especially the minorities, lose their chance to take part in important decisions or get update about the company monies. The court ruled this is unfair treatment and said they can take legal action to protect their right. Next, director faced personal liability for this failure. The court confirmed their breach of duty, risking reputational damage and disqualification from the future roles. The last one is the value of the company share goes down because investors feel unsafe and the company is not managed well. The share value can get better if the company start holding regular meeting and keep clear financial record. But if the fight and problem continue, the share value may keep going down.
So, in a nutshell, ignoring this issue is just like a run a business blindfolded. You are bound to crash. Good corporate governance, clear communication, and following the rule are just a fancy word. They are GPS that keep the company on the right track. Otherwise, shareholder get lost, director hit the bumps, and the whole company might just spin out of control. So let's keep the wheel turned smoothly, right?
The company, its shareholder, the director,
Dah, boleh.